U.S. immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead, put your questions in the comments now while I'm here. So as soon as I see your questions, I'll go ahead and answer your those questions. I have a great topic for you today. So the topic that I want to talk about is the children, right? The children, how can the children qualify for VAWA? Now, when I'm talking about children, I mean the children of someone who's applying for VAWA. Do they qualify and how does that work? So there are two scenarios I'm going to talk about here. And the first scenario is where the children are here in the United States. So I have had cases where not only the spouse of the US citizen qualified, but also the children who are the stepchildren of the US citizen or legal permanent resident, they independently qualified because the abusive behavior, the mistreatment, not only was imposed on the spouse but also on his or her children. And so, whenever I see cases like this, where you have a spouse and you have the spouse's immigrant children who are involved, I always look to see whether they independently qualify to apply for VAWA. But even in the case that, say, the abusive spouse, U.S. citizen or legal permanent resident spouse, did not abuse or mistreat the children. Maybe they treated them nicely, but they extended the mistreatment and the abuse towards the spouse only. Do the children, if that immigrant spouse was to walk away from the marriage, or if they wanted to control their process themselves, will the children be involved? This is usually the deciding factor for some of my clients to determine whether they even want to go on their own. In some cases, it's beyond their control. They have to do it urgently, control their process through VAWA. But in other cases where they're trying to figure out their options, they're in a terrible situation, but they want to make sure that the decision they make is not going to hurt their kids as well. They have this question: can my children qualify for any status if they were to go ahead and apply for VAWA? And the answer is yes. So the children can be included in the same VAWA petition as the immigrant who's applying for VAWA instead of going through the marriage-based process. Keep in mind, though, that the way that this is going to work is going to be different, right? Because the children, they're added to the petition as derivatives. But what happens is the spouse, so the spouse who's experiencing the mistreatment, they apply for VAWA. They apply for VAWA, and more than likely now they can also apply for adjustment of status, which is to get the green card. They can also apply for their work permit and their travel document all at one time. However, the children will only be included on the VAWA petition, which means as soon as the VAWA petition is approved, or on, the children can't really do anything with that status until the VAWA is approved. And that's if they're in the United States. So if the children are in the United States, they're included on the VAWA petition, and then the VAWA petition is approved, the children can then go ahead and apply for deferred action based on that new VAWA status. In the meantime, what's going to happen now is that there is going to be an adjustment of status filed, and the children can also file an adjustment of status application to get permanent residence with the mom. So, or the mom or the dad, whichever one is being mistreated. Now, if the children are outside of the United States, it's going to be different. And then keep in mind now that the adjustment of status is going to be based on, or their status is going to be based on the parent status, right? So if they become a permanent resident, then the kids can qualify. But if for some reason the whatever is happening with the parents is disqualifying them and it extends to the children, it can then stop all of them from getting permanent residence. So you want to make sure that you're represented and that you have all of these evaluated beforehand so that you go through the process smoothly and you know what to expect. Now, in the case that the children, and thanks so much for the love, I appreciate it. Now, say the children are outside of the United States, how does this work? So, with the children outside of the United States, once again, they're going to have to wait for the VAWA to be approved. Now, once the VAWA is approved and then the spouse applies for adjustment of status, or the immigrant spouse who is here applies for adjustment of status, it's going to then go automatically to the green card process. At the point that the person does get adjustment of status approved, then this case will be moved to the National Visa Center to then process the children who were on that approved VAWA to be able to come here and then become permanent resident. So they are going to have to wait for the adjustment of status process to be completed before the children can then get their permanent residence in the United States. But the great thing about this is that you do get a process that's your own process that you do have control over. You get to keep, now, if your children are here, you get to keep them in a healthy environment without the fear of a spouse mistreating them or being at the mercy of a spouse. And then in addition to that, they do go along with you. You don't leave your children behind. When you get status, your children will then get status as well. So it allows not only you, and the children don't have to be abused. They don't have to be mistreated to go along with you as a parent. But keep in mind that if the parent, if the keep in mind that if the children themselves also experience mistreatment, then it means that they could possibly qualify independently for VAWA. Because if the step parent is a permanent resident or a US citizen, then that also qualifies them for VAWA. So not so in this case, don't just think that because your children are the stepchildren, they won't qualify for VAWA. Stepchildren do qualify for VAWA, but the stepchildren under immigration law, they have to meet a very precise definition of a stepchild. So the stepchild the marriage to the immigrant parent has to be before the child turned 18 for this to qualify. And as long as this is filed before the child is 21, the VAWA, then they're good. However, if they never got married, so if this child never got married, if this parent, the US citizen or resident, never married the immigrant spouse before the child turned 18, they were already 18, then unfortunately they would not be considered a stepchild under immigration law. The same works for, say, you are the step parent of a US citizen who mistreated you, a US citizen stepchild who mistreated you. The same does apply, is that you would have had to be the step parent of this US citizen before they turned 18 to qualify, even though you have to still wait for that child to be 21 or over to apply for VAWA as the step parent. You still have to show that you meet the requirements of, or the definition of, a stepchild or step parent under immigration law. So keep that in mind going forward. But children don't get left behind in this process. They get to go along with you. If they're here in the United States, you get approved for your VAWA petition gets approved. They can then get deferred action and move on to the permanent residence process with you. How long does it take normally to get the work permit after submitting all forms running concurrently? So it depends. If you're filing for the marriage based, you could be seeing it 3 to 6 months. If it's the VAWA, you could be seeing it 6 to 12 months. Why do NVC take so long to schedule an interview after being documentarily qualified? They're backed up right now. Can you help someone to get a visa sponsorship and work? So it's going to depend. I don't help to place people with employers, so that's not what I do. I work with employers to get the petitions approved. I work with family members to get a petition approved and get everything worked out. I help people to get their green cards while they're here in the United States, even if they're out of status. But I don't help people to actually find the sponsors. Um, all right, put those questions in the comments because I'm here to take your questions. So how long does it take? I don't know which process you're talking about. If you're referring to VAWA, I'll just go ahead and clarify your question. Okay, so what stage are you eligible to work in? So I work in all 50 states and around the globe. So as a US immigration attorney, we can do that. We can do that because it's a federal practice, meaning that there are USCIS offices, there are immigration courts all around the country, and they all work together. So when you're in one state, you're not going to file your paperwork you may not, it may be a coincidence, but you may not be filing your paperwork in the same state. We have to work with USCIS offices in other states when we're filing. And so it's not necessarily where you live that matters because it's all a federal agency. So we work with agencies all around the country. I also travel around the country to represent and support my clients. And I also have clients all over the world because we do have to work with the US embassies and the National Visa Center that works worldwide. So no matter where you are, I can assist you. My fiance went to prison after we got engaged. He does not meet the income requirement. Which route do you suggest we go? Now with your fiance, so you're in Canada and he's in the United States. So your case is a little more complex, just because of the different factors involved. Now, if he does not meet the income requirements, then you would be looking at a co-sponsor. So that's one possible option. But then also, if your fiance went to prison, the other would be what are the charges involved and could those charges affect their ability to petition for you. Also, as the fiance of, he would not be able to petition for you until you are married. And so the other option as a fiance would be the fiance visa. So the thing that we'd have to look at are the charges involved and then the logistics of it all and whether it can work. Because usually, first of all, how long is the prison term? Because remember also that when you're applying for the fiance visa, you're applying to come to the United States to get married within 90 days. So is that a possibility? So go ahead, give us a call and we'll evaluate what's going on and then determine how to move forward. How long normally does take approval for VAWA before the green card? So I'm seeing 2 to 2.5 years right now. Please, is it possible to expedite the green card application after VAWA approval? Also, is it normal not to have gotten prima facie or RFE after almost 2 years of filing? So now, if you have received a VAWA approval, you're no longer going to get the the prima facie. And that also means that they've made a decision on your VAWA application. So it's unlikely that you're going to get an RFE related to the VAWA. However, before they have made a decision, you can get both a prima facie or an RFE at any point in the process, at any point before they've made a decision. Is it normal to not, that after you filed, you've never received a prima facie? No, that is not normal. If you have not received a prima facie within 6 months to a year after filing, then you want to make sure to check if you are, if they are processing your application, that everything is going well, that they have the correct address for your application. Usually, as the attorney, I do get to work, send emails to the USCIS directly. There is a special VAWA unit where we send emails directly, and it does make it a little easier, and believe it or not, even a little faster. However, if you're not represented by an attorney, you do have to do everything in writing, which can get very frustrating because things get lost a lot. And they tend not to respond to those or take very, very long to respond to any mail correspondence. So that's another reason why representation matters, is that we're able to effectively communicate with them when there are questions like this where maybe something is taking too long or correspondence doesn't seem to be coming through. You want to make sure that you have a good line of communication with the USCIS. How long after VAWA approval before I get the green card? So I wouldn't be able to tell you how long that's going to take just because I don't know your case. I'm not your attorney. And if you do have an attorney, it's always best to check with the attorney to see what's going on. However, what I can tell you is that the timeline that I'm seeing right now is 2 to 2.5 years to get a VAWA decision. And then after that, it's another 6 months to a year to just move on to the permanent resident process to get the permanent residence. All right. Can immigrants still travel by air within the US or have the restrictions come into effect? So I believe they did extend that real ID law. Um, so can immigrants still travel by air? I believe they can still, but you don't, if you are traveling and you have your doubts, make sure you always get legal advice. Don't take any actions by me just saying something on a live, because what I may have in mind may not be your situation. So always make sure you get legal advice, because you, as an immigrant who maybe has run out of status, you're always going to face a risk, though small in some cases. You're always going to face a risk that something bad could happen, that you could be detained, or something could happen while you're traveling within the United States because of the lack of an immigration status in the United States. However, traveling solely within the United States with your passport is acceptable at this time. However, that may change, or that may have changed. So I'd have to check the updates, but I believe they did change extend the real ID law. So that I don't believe is in effect yet, but I'll have to check. Can I get the green card if the spouse is mistreating me and she isn't a citizen? So with this case, there are some alternatives. So this is about what is happening in your situation, and whether there are alternatives, right? Because a lot of people don't know that there are alternatives. So one is, okay, you have a spouse, they're not a citizen, but are they a permanent resident? If they're a permanent resident, then you still are able to apply for your own permanent residence based on the permanent resident spouse and the mistreatment. If they are neither a citizen or a permanent resident, then what is the nature? I would really have to evaluate what's the nature of the mistreatment. Because if it's a situation where they have you here and now they're doing things to hold you against your will, they're forcing you to do acts against your will, you're finding that maybe you're doing work in the house, maybe you're doing things that you didn't want to do that the spouse is telling you have to do. Maybe you're even having a sexual relationship with someone you no longer want to have a sexual relationship with, but because they're holding this over your head and threatening you, you feel like you have to continue like this. That could possibly be a form of trafficking. And so there is an alternative. If I do determine that there is a form of trafficking going on in regards to an intimate spouse, then we do go ahead and apply for that, because the person who's doing the trafficking, who's doing the threatening, the mistreatment, they don't need to be a citizen or a resident to qualify the immigrant for a T visa. So this is where the consultation is very important, because it's about legal analysis at this point. So if you file both concurrently, VAWA green card is a timeline used for the green card when it is first filed. So first, it's going to be dependent on the VAWA petition. Once the VAWA petition is approved, then it's going to move on to the green card. So you really have to look at the VAWA petition first, and then move on to the adjustment of status process. Once your VAWA has been approved, it moves on to the adjustment of status process. And so the adjustment of status process, you can count it from the time of approval to the point where you are approved, because they can't approve the adjustment of status without the approved VAWA. So you have to look at that first. But adjustment of status can take anywhere from 6 months to another year. That's my experience. However, keep in mind that cases are different, results may be different from person to person, and especially in your case where you may be filing it on your own, you may be using an attorney. It's all going to be dependent on what does that application look like, what's in your application, and so forth. All right, so I am going to head out in a quick minute. I'm going to try to go through a few more questions. As a joint sponsor, have to have a close relationship with me. I have checked, and the charges will not interfere. So they can be, they don't have to have a relationship with you necessarily. They don't have to have, for example, that you don't have to show that they're family. Um, they can be a friend, they can be a relative, they can be an acquaintance. Is there any way to adjust status after enrolling in college if the person overstayed? Not just based on enrolling in college. You have to have some other way to qualify: family, employer, VAWA, T status, U status. To petition for a fiance visa or marriage visa and any visa, I'll have to see my fiance within 2 years, right? It will be 2 years in April since I've physically visited him. So yes, that is a requirement. Go ahead, schedule the appointment, and we can talk, because your matter is, as you can see, there are things that we have to consider here. Which name should you use when traveling internationally? The name on your passport or the one on your green card. So the one on your passport, is your legal name. And it depends what's the one on the green card. Is it a mistake? Is it marriage based? But if you've been using the one in your passport all along, then use that and then explain the discrepancy there. How long does the adjustment of status take to be completed? Also, how long for a travel document or permit to allow to legally work? Adjustment of status, I've seen anywhere from 5 months to a little over a year. It depends on the type of adjustment of status. Um, and the work permit, 3 to 6 months. All right. So I have to head out. We're getting, people started on their matter. So I'm jumping into another appointment here. I'll be back tomorrow. We'll answer more of your questions. You can always get in touch to schedule your appointment. Thanks everyone for your time. To get information and advice about your particular case, you need to schedule a consultation. So, man, we don't expedite cases for people unless they're our clients. So you have to be our clients who we have been working on your case from beginning to end to be able to work to expedite your case. Otherwise, we don't just take cases to expedite applications. So people who have already filed, we don't take those to just expedite their case. All right. Thanks, everyone. Have a great day. I'll see you tomorrow at around lunchtime where I'll continue to answer your questions. Thanks for your love. Remember to like, subscribe, share this live. Let people know that I do come around this time to give you good information, to guide you and empower you through your process and also to help you. All right. Have a good one. Bye-bye.